Hi, I'm Love Kingsbury. I'm a family support specialist here at PTSI. And so tonight we are so excited to welcome the Legal Aid Justice Center. We have attorneys Amy Walters and Cassie Powell here, and they're going to be talking about juvenile justice. This is a 5-part webinar series that we are super excited is going to be held every other Thursday at 6:30. So the link that you use tonight will be the link that you use to access it in the future. But don't worry, we'll be sending out reminders to you. So I want to give you a little bit of information about our presenters. Cassie Powell. Cassie joined the Legal Aid Justice Center's Youth Justice Program in 2019. Her work focuses broadly on education, civil rights matters, often using community lawyering lens. Prior to joining LAJC, she worked as a staff attorney at the Virginia Legal Aid Society in Suffolk, where her practice focused on public benefits and education law. Before beginning at VLAS, Cassie was a law clerk at the Family Court of Delaware, one of the few unified family courts in the country. Cassie completed the dual law and Master of Social Work degree program offered by the University of Richmond School of Law and Virginia Commonwealth University School of Social Work. Amy Walters. Amy joined the Legal Aid Justice Center in 2014. She represents clients in a variety of legal matters, including education, juvenile justice, public benefits, and health law, and co-directs the University of Virginia's Youth Advocacy Clinic and Health and Disability Law Clinic. She is a graduate of the University of Virginia Law School, and she previously worked for Maryland Disability Law Center as a Skadden Fellow representing court-involved youth. Prior to becoming an attorney, Walters conducted psychological research on females placed in Virginia's Department of Juvenile Justice, taught dramatic empowerment in the Washington, D.C. public schools, and served as a court-appointed special advocate. She completed a clerkship in the U.S. District Court for the Eastern District of Virginia. So, saying all that, we are in the very, very, very best of hands tonight. I'm super excited to hear what they're going to teach us. So without further ado, I'm going to introduce them and I'm going to disappear. Thanks so much.
Thank you so much. That's way too kind. Hi, everybody. So as you heard, this is day 1 of a 5-part series. And so really it's the introduction week. And so we're going to be brushing, using broad strokes, to cover things. And then future presentations will take deeper dives into the matters that we're talking about. But I just first want to say welcome to you. I mean, welcome and thank you for being here. If my understanding is correct, most of the people listening to this are parents of students with disabilities. And the fact that you're here amazes me, even if here means that you're listening to this later because you are on the recording and you're not missing this like dinner hour. Still, it's incredible to me that you're making space for thought and learning on these issues, for advocacy, for collaboration with other PTSI families. I'm really impressed. And so I really hope to honor your time by showing up tonight prepared. And so I'm going to be leading the presentation tonight and Cassie is going to be going through the slides. And in a full disclosure, I have paper notes here, so I apologize if I look down at them. And second full disclosure is that I have this virtual background because I'm hiding from my family so they don't interrupt us in my closet. So I will spare you that, but just to add a little bit of realness to this. Okay, so we can get to the next slide, Cassie. Thank you. So here's my goals for, well, I'll give her a chance to do that. Let's see. Thanks. So here's my goals for today. I want to define the school to prison pipeline for y'all and talk about how this impacts students with disabilities in particular. I also want to provide the overview that I said I would about school discipline and the juvenile justice system. And then lastly, with the school year starting, I want to make sure that you've got some tips and things to get you started on your sort of parental advocacy journey. And through this presentation, we want you as parents to reclaim your autonomy. That's a phrase that a colleague used that I love. So reclaim your autonomy when it comes to this discipline process and the juvenile court process. Hopefully through this information, you'll be able to be an active participant rather than passive participant if you find yourself in these situations. All right, next slide, Cassie. Thanks. So school to prison pipeline, what do we mean? When I started this work, I primarily thought about school to prison pipeline as push out of school and into incarceration. And that being primarily in the form of exclusion from school, like suspensions and expulsions. The school literally saying, you know, you did something wrong, you're not welcome here, you have to be out for X number of days. And if you try to come back before that, we might charge you with trespassing. But other examples of school push out might be not providing a realistic path to graduation or to the workforce based on the offerings they have. For example, not meeting a student's academic needs so that they can succeed, or say not providing credit recovery. You know, the number of 11th and 12th grade kids I've represented who had 1 or 2 credits, no reasonable path to graduation. That's a form of push out. It could also look like placing students in inappropriate environments, you know, alternative schools or in-school suspension locations or separate classrooms, things that don't meet their needs. And so we thought of school to prison pipeline as this being these push out mechanisms. But then advocates kind of quickly realized that in addition to this pipeline, there's also this direct shoot of school-based arrests where kids are literally being removed from school and placed into the justice system. And these arrests could be for minor misbehavior, things like, you know, trespassing in a part of the school that they're not supposed to, or it could be for things that are just typical adolescent behavior, right? Fighting, possessing tobacco, things like that. I want to just take a minute to say, the way I'm talking about this is in a very academic way, right? I'm like, let's define the school to prison pipeline. And I want to acknowledge that, in that I am a witness to this system and sometimes a participant in it. And I'm not speaking from my own lived experience, right? And so for some of you who have experienced this, meaning suspensions and arrests, I want to acknowledge that this is often an emotional and traumatizing experience for kids and their families. And if you've lived this, you don't need to name it or define it or look at the statistics of it. I mean, you know it. So if you want to sign off or step out, go be it. I just want to acknowledge there's nothing, you know, this is not a substitute for the lived experience and more aimed at a broad overview for those who perhaps have not had that personal experience. So going back to academic, Amy, the next slide, please. What is the pipeline, the school to prison pipeline? It's the system of laws and policies and practices that push students out of school and onto a path into the juvenile criminal justice system. And I just think this graphic is so telling, right? We've got this little guy, he's like starting kindergarten, he's got his pencil and he's like ready to go. And then at some point in the process, right, maybe he's still in school, but he's not engaged. And that turns into then exclusion from school in some respect, right? Here's this kid sitting outside, not in school, which then leads to incarceration, criminal justice involvement at some point. And I think we all know that if we could just maintain that like little guy's optimism with his pencil and that feeling of like, I belong and this is for me and I can succeed here, we wouldn't end up in those last images. Thanks, Cassie. Okay, so now I'm going to name what we all know, which is that this is a racial crisis, and this is also one disproportionately affecting students with disabilities. But the numbers are telling, so I want to spend a little bit of time reflecting on this graphic. So what this is showing us, now the data is a little old, it's from 2013, and this is national data, but it's the chance of a white student being suspended at least once is 1 in 20, so 5%, whereas a Black student 1 in 6. And when you look at the intersectionality of race and disability, a Black student with disability, 1 in 4, 25% chance of being suspended in school. And like, what does this say, you know, about our culture, about our schools, about our country, that if you're a Black student with a disability, you have a 25% chance likelihood of being excluded from school, right? I think that names it largely, the school to prison pipeline. Next slide, Cassie. And perhaps not a surprise to folks, what this slide shows is that Virginia stinks. Virginia is the 9th worst for racial disparities. And so what this graph shows us is the number of, well, the gap in the days of instruction lost by race and students with disabilities carved out. And so the first column going down vertically is a Black-white student gap. So the difference, right, at 118. And then the last column we're looking at is students with disabilities. And you can contrast that with the second to last and third from last carved out for Black students and white students. So it's a number of days lost, right? When you're being suspended, you're missing in-time instruction. So this shows the same point as the previous slide, right? The disproportionality there. But what this takes into account is not, the last slide told us about your chance of being suspended once. What this slide tells us is that, or what this graph tells us, is that not only is it that you're likely to be suspended, you're likely to be suspended for longer or more often, meaning you're going to miss more days in school. The disproportionality continues to be bad and get worse as we look at those additional factors. Next slide. This is very grim. This slide shows us that actually the same data as the last, but the last was drawing out Virginia specifically. And here we're looking at national trends, but I actually find this graph to be much more accessible because you've got those numbers. And so the first columns are showing the days lost, right? Average, that's average for everybody. But then you can look at the second column, which is for Black students, and the last column, which is for students with disabilities, really showing that disproportionality of how these students miss more school, way more school because of suspensions than their peers. And so going back to the pipeline, thinking about, why are we thinking of a suspension as pushing kids out of school? The psychological factors are self-evident, right? I've sort of said this before, but school's not a place for you, right? That's what a suspension tells a kid. But it's also missed instruction time as shown here. I mean, you miss school and then you come back behind your peers and you miss out on that continuity and you miss out on the school related activities. A lot of kids don't like school, but they're there for their friendships or they're there for the soccer or whatever it is. They miss out that all of that is disrupted by a suspension or expulsion. And so it's no surprise that then suspensions are tied with increased probability of grade retention, school dropout, and involvement in the juvenile justice system. Thanks, Cassie. Okay, and now I'm going to take a pause and have you look at this data. This data is Virginia specific. And what we're looking at here, this is from 2015, 2016. Data is always a little bit old, but these are the 12 most common reasons for suspension in Virginia those years. And I want you to just take a look at it. And you can't talk to me, so I can't hear your thoughts, and I'm not capable of monitoring the chat really. So I'll just tell you the answer, which is that these offenses largely involve discretion, right? What is defiance? What is a classroom disruption? When is something, obscene or disrespectful, right? And what do we know about us, right? We know that when people exercise their discretion, they bring in ableist and racist subconscious and biases. And so what you see is at these points where people are exercising their discretion, that's where you see these racial disparities come out the worst. So it's no wonder that our suspensions are so disparate by students with disabilities and for Black students, because the lens at which their behavior is looking is coming from these biases. And Virginia law does not provide any sort of like backstop here, right? Virginia law just says localities can suspend kids for sufficient cause, like that's it. So then it's up to school systems and then really a specific individual administrator to determine what is sufficient cause. And they define what that means. Next slide. All right, so I talked about the pipeline and I talked about the direct shoot, right? And so I'm going to turn now to that direct shoot of school-based arrests. It wasn't that long ago that Virginia was all over the news as being the #1 worst state for school-based arrests, meaning we had more school-based arrests than any other state. There is some pushback on whether the data that was submitted to draw that conclusion was actually accurate. Maybe it was just police context and not arrests. Doesn't matter. We're doing a terrible job, right? And a surprise to no one, if you look at this sort of graphic in the bottom corner, Black students and students with disabilities are highly disproportionately more likely to be arrested in school than their peers. And so this is a problem. Clearly, this is a problem, right? You probably all knew this is a problem. I'm telling you nothing new, but it's, you know, why we want to be talking about this, because it's something for you to be considering for your own child and for their peers. But there is good news here, right? There is good news, which is that times are changing, and a lot of this data is old and the numbers were improving even before COVID. And there's political momentum to change the status quo. And so now I want to shift to, Cassie, if you don't mind doing the next slide. The conversations happening right now. What's going on currently with school discipline and policing in Virginia? Well, largely in Virginia, the conversations we're having mirror national conversations about schools, policing, prison reform. And as a society, we're kind of asking ourselves questions about how to, we know about these disparities, we know about what's happening. And so we're asking, do we need more policing because of gun violence and these mass shootings, or do we need less policing to work towards equity? Do we need stricter discipline to combat bullying and focus schools' limited, very limited resources on those kids without behavioral issues? Or can we effectively respond to misconduct in other ways? Do we decriminalize certain crimes? And if so, what approach should we take instead? And then how does our growing understanding of brain science and adolescent development, you know, what it means to be a young person and the impacts of trauma, right? How does our growing understanding of that affect the policies and the way we treat kids? So these are all conversations we're having, courts are having, policymakers are having. Next slide, Cassie. And more specifically, I want to talk about the legislative changes happening in Virginia in the past 2 to 3 years to combat the school to prison pipeline. So to run through a list, kids in 3rd grade can no longer be suspended for more than 3 days without aggravating circumstances, right? We're capping how long these little guys can be out of school. Long-term suspensions have been capped at 45 days for all students except in special circumstances. Students can't be charged with disorderly conduct in school. Before, it was, I think, the 3rd most common charge that students got in school, which is bunkers, because who didn't disorderly conduct in school? But we got that off the books. Evidence of a child's disability is now admissible and relevant in juvenile proceedings when they're considering whether a child should be adjudicated delinquent of a crime. Circuit courts, so this is when a kid is charged as an adult and going through that process. Now the law says they have to take into account adverse childhood experiences, early childhood trauma, any child welfare agency involvement, and the inherent differences between juvenile and adult offenders. So those are some examples at the state level. Locally, we're also seeing in the news, like as recently as last week, school districts modifying their own policies. So terminating contracts with school police and then shifting those resources into mental health or other funds for kids. Here I featured Arlington and Alexandria. And what the graph, it's really hard to see, at least on my screen because it's teeny tiny, but what the graph is showing with the blue and the purple lines is that the racial disparities in the juvenile justice system in Virginia are down. They're down 31%, which is fantastic. These were declining. Oh, and I did mention for suspension and arrests were declining before COVID, more so now. But this trend in minimizing the racial disparities in the juvenile justice system is attributable to changes at the policing level, changes at intake, and largely changes within the Department of Juvenile Justice itself in Virginia. So there is hope, right? I know this is really dark and dismal, but Optimistic Amy does say that the future is brighter and that we're going to get more equitable treatment and opportunities for all children that keep them in the classroom, but also recognizing that we're not there yet. So this next part of the presentation, I'm hoping would focus on kind of what you as parents should know if you have to navigate these systems. This next slide, please. Okay, so in future sessions, as I mentioned, we're going to get more into detail about the discipline process in school and the juvenile court process and the rights that you and your child have as if you have to go through this. But for now, the goal is to kind of demonstrate how this plays out on the ground for an individual and to get you to see sort of the bird's eye view of it. So then we can zoom in. And again, if you've lived this, you know, unfortunately. But I'm going to use Michael, hypothetical student, to talk us through this. So Michael is a hypothetical 10th grader with an IEP for ADHD. And a classmate reports that Michael is trying to sell prescription drugs at school. He reports this to a teacher. Teacher tells the administrator and the school resource officer, and they approach Michael. And the school administrator searches Michael's backpack and finds this bottle of prescription pills. So what happens next? When do you as a parent, you know, even find out that something's going on here? Next slide. So for school discipline matters that are also crimes, students kind of get on two parallel tracks, right? For the misconduct in school, they've got the disciplinary track that the school administrators are going through. And then they've also got sort of the policing juvenile court track. And these two things are kind of happening in parallel. So I'm going to break them apart here. But for families going through this, this often feels really unfair because it feels like two bites of the apple for the same thing. And a positive outcome in one, you know, like, oh, you know, we didn't get suspended. We convinced him I was safe to stay in school, doesn't mean a positive outcome in the other. Like, oh, but I still have to go through with this court proceeding and face whatever penalty the court's going to give me. So I'll start with a school here. So the incident happened, right? First, and that's his first little bubble. And just like in Michael's case, often the school administrator will approach a student, I'm calling it a student interview, before you as a parent even have any idea that this is happening. And based on that, based on maybe interviews with other kids, that local school administrator will make a decision about the suspension. Or I'm just saying suspension here. There are, of course, other disciplinary consequences, but I'm going to talk about this. And, you know, probably what a real life example would be is schools are really hard on things like drug distribution. And so in Michael's case, they would probably recommend a long-term suspension, if not an expulsion. And so at that point, when that person, usually the principal, has made that decision, then the parent gets usually a phone call, but also written notice. At that point, what happens can very much depend on the locality. Virginia is all about giving local control. If you didn't know yet, you know, the way your school system does something is probably very different than another county or city does it. So what I put here is kind of what I've seen as the most common, but what the law just says is once that principal makes that decision about the, you know, long-term suspension, then there has to be some level of a review, right? If you want to fight that, you get some level of review. Some areas, like where I live, I'm in Charlottesville, or my kids are in Albemarle, it would go first to a superintendent to review, and the superintendent would have to sign off on it. And then if I wanted to fight it, I would get to go before a disciplinary committee of the school board, and then maybe even the full school board, right? So I've got a lot of chances to try to overturn it. Whereas I know some other counties where we've taken cases, it goes just straight from the principal of the school board, and that's it. That's kind of fighting it. What I want to call your attention to is students with disabilities, and Cassie will get way more into all of this next time we meet, but students with disabilities have a protection from the IDEA, you know, the main special ed law, saying that if you're recommended for suspension for more than 10 days, right, you get a manifestation determination review. And this is an IEP team meeting where your IEP team convenes and discusses whether the conduct for which you're being suspended was a manifestation of your disability caused by your disability or the school's failure to implement your IEP. And in theory, if the answer to either of those is yes, the child shouldn't be suspended. Of course, like anything, there's exceptions. And so in Michael's case, he actually falls into an exception because of drugs. So he could still be suspended, even if the IEP team said, look, Michael's got ADHD, he's really impulsive and was self-medicating with these prescription drugs or whatever. We think it's a manifestation, but he still could be suspended because it's in one of these kind of carve-out exceptions. But let's pretend it's not Michael, and let's talk about another case of a kid where maybe it's a fight in school, and that's the thing that's leading to the suspension. The IEP team would convene to have that manifestation determination review. And if you as a parent really strongly believe that this fight was a direct result of the disability, perhaps your child was being picked on because of their disability and they're fighting back, or you think it's a result of the kid's IEP not being implemented, like a behavior plan, a really robust behavior plan should have indications of how the school should be changing their conduct to help your child not have behavioral problems, right? If they fail to do that, right? If the behavior plan says when Michael's escalating, don't touch him, give him space. And Michael's escalating and an administrator lays hands on Michael, thinking they're calming him down, and then Michael reacts, right, and assaults administrator, I would argue that the school failed to implement the IEP by failing to implement the behavior intervention plan, and that Michael should not be suspended, right? This is part of his IEP. I know I got in a little weeds there. Sorry, Cassie, you'll probably cover that in a couple of weeks. But anyway, my point being is, if you disagree with that team's decision, right? We think that it was a manifestation, we mom people, but the school disagrees. If you want to appeal that, whether it was a manifestation, that goes through the normal IDEA appeal process, meaning a due process hearing. So kind of in the school track, you've got two ways to fight it. But they address different things. The principal or administrator's decision and superintendent's review and school board, that appeal process is going to be, should the kid be suspended? And maybe the question of alternative ed, if they are. The other is, was this a manifestation, and appealing that. Okay, Cassie, go to the next one. So, and I think I said this, but if I go really into the weeds because I can't help myself, like with that, it's okay. Like, you are not expected to retain this. I just kind of want you to kind of see the full arc of this, and then you can get a deeper dive. And even though I've been practicing in this area since like 2010, I still will forget it and look it up in a book, and there are resources available to you to look these things up. So don't worry if you're not catching everything. But now I want to turn into the court involvement piece, right? Because going back to remember Michael's case, he was approached by a school resource officer and an administrator. So what to the administrator felt like an interview, maybe I'm going to find out from Michael what's going on here in the context of the school resource officer, a police contact, this could very much be like an interrogation, right? And what rights attached to Michael and what rights attached to you as a parent can depend on who's doing the talking, who's doing the searching of the backpack to see the pill bottle, and whether Michael's under arrest or felt free to leave and things like that. So we'll get more into that in the future, but this is certainly an area of tension that can be blurred. So thinking about Michael and what he would experience if he goes through the law enforcement and court process, right? There's that initial police contact, and what happens from there can vary wildly. Most often, I would say that he would be issued a summons, meaning here's the date and time that you, as a parent, and Michael need to appear probably before a court services intake, meaning that it's probably going to go on to juvenile court, but it's in paper. Nothing's, he's not handcuffed right then. An officer will take a kid into custody if they think that detention is warranted, which is, because they think they're a danger to the community or something like that. But police do have diversion programs, meaning that maybe the police officer believes that a crime was committed, but that going through the court process is not necessary to resolve the issue and keep the community safe and the factors they're considering, right? They might go into some sort of police diversion program that offers community service and a letter of apology or something like that. Or the officer could exercise their discretion and just say like, oh, Michael's a good kid, like I'm not going to do anything with this, right? And so going back to my point earlier about sort of when people exercise their discretion, when social scientists and other policy people have broken down why are there these disparities in the juvenile justice system, they look at these choice points, these times when people exercise their discretion. And what happens is, there's a smaller disparity at deciding who's diverted for police and who's thwarted. And then there's another disparity at the next level and another disparity about, who decides to be, who do we think should be locked up pending their hearing and who shouldn't, and another disparity about the outcomes of those hearings, right? And then those in the aggregate lead to these really wide disparities in between who's behind bars. So it kind of happens at each step in the game. So think about it here. But going back to Michael, right? Michael, let's say that he is summons issues, as I said. This is, a piece of paper that you're getting as a family that's saying you need to go to the court services unit, which in Virginia, usually, all this stuff is really hard because there's always exceptions. So I'm saying the most common fact pattern. Usually this means you go to an intake at the court services unit, which is the same kind of people who are parole officers and part of DJJ for youth, Department of Juvenile Justice, DJJ. At that intake meeting, I'll get more into this in a couple of weeks, but to me, this is a huge opportunity for families to try to put the brakes on this process. And so this is a meeting to decide whether the case needs to go to court or not. And there's no lawyer yet at this meeting. It's informal, but so it's a chance for the parent and the child perhaps to advocate for themselves. A lawyer wouldn't come involved until this first court appearance that you see in the top corner. Okay, so I think that's all I'm going to cover there. Let me just check my notes. So as I mentioned before, this sort of court process is happening often simultaneously with the school discipline process, and it is a lot for families to handle. And for the people doing it, right, the CSU intake worker and the school board disciplinary officer and people like that, this is, they do this every day. This is routine. But for you, it's often a big upheaval for families. So it's important to know what's going on, and it's often hard to know what's going on. So again, hopefully we're helping a little bit of that with today's presentation. Cassie, next slide, please. And again, we'll talk about this more in future sessions, but there are limits and rights attached to these discipline and juvenile proceedings. As a parent going through the process, right, it often feels like a train on a track with no brakes. And sometimes that's true, right? Sometimes there is nothing you can do to intervene to stop this train from going. But there are laws in place to protect you, right? So like the US Constitution, right? Just last week, the Supreme Court imposed limits on what a school could do, what a school could suspend for. I don't know if y'all saw the case, but involved a social media text that happened outside of school. And the Supreme Court said, yeah, there are limits on what you can suspend for in school. And so whether it's free speech or the rights of parents to rear their children in the way they think right, or your right to an attorney, or your right to due process, meaning like the process due to you before we deprive you of something, typically notice and an opportunity to tell your side of the story, right? That's the due process that's attached that you get before your child gets before being removed from school. All this, the Constitution applies. And same with Virginia law and the Virginia's Constitution. Their Virginia laws to protect your child. Education's a fundamental right in Virginia. And there's a mandate in the juvenile code saying that children who interact with the juvenile justice system need to be kept in the community where possible, right? Similar to the LRE provision in the IDEA. And then, of course, for students with disabilities in particular, there's the IDEA that protects students, as we saw, the manifestation determination review, and then other disability discrimination laws that kick in here. Okay, so now I want to turn to, next slide, please, Cassie. Kind of run a wrap up before we get to questions talking about parent advocacy, where to start. Because I know I've given you kind of this grim picture, but what I would say is know your school, right? Know how your school is doing in terms of school climate. When we talk about that, part of that is what's happening with suspensions in your school and are kids in schools feeling safe. And so we've put a couple of resources on this slide where you can go and look up your specific school district, your specific school to see what's happening there. So there's the schoolquality.virginia.gov. There's, if you want to see how many kids are being suspended in my child's school and how disproportionate is this for students with disabilities, you can go to Virginia Department of Education's website, pull up those stats, right? And use that in your own advocacy, right? Call it out. You can use the civil rights data collection, which would talk about school-based arrests, things like that. So those are data available to you. I would also say know your school's code of conduct, right? It's by law in Virginia, it's got to be published on the website. We probably all sign something as parents saying we read it, but we don't actually read it. But then when you start imagining like, wait, what is my child going to be punished for? And what discretion does, if Michael were my child, does the principal have any discretion not to do a long-term suspension or expulsion? Questions like that. Do they have these vague offenses there, like disorderly conduct? It can't be a crime, but it can be in school. It could be a school disciplinary process. So look at that. And provide feedback and know if your school has a school resource officer in it. And if so, there should be a memorandum of understanding between the school district and the police force. Look at that, see what it says. Are the school resource officers are the lines blurred and they're responding to what's just kind of normal kid conduct in school, what should just be a school discipline matter? And then look at your schools, follow along, I'm sure you all are, but your school districts, board meetings, their agendas can kind of tell you what's coming up and their meeting minutes. I mean, these have been all over the news lately for other issues, but school policing has been one that's come up in a lot of school systems in Virginia over the past couple of months about whether to have police in schools. And often during these school board meetings, school board members will be presented with data and looking at how their own school system is doing on the disciplinary factors and talking about how to respond. Okay, next slide. And then this is probably things y'all know, but I honestly think it never hurts to hear it again, right? So just because I know I'm kind of jumping ahead here because we did this overview, but the school year is starting and you want, to have your A game, right? I'm going to give you tips that you probably all know from being parents of kids with disabilities. But one, be an excellent record keeper, right? Like have your binder. I've had clients with their binders and their tabs, and it's so awesome. Keep every piece of paper that the school gives you and demand it to be in writing if they didn't give you the piece of paper, right? Keep logs of your calls with the school. Like a common problem we see is schools calling you, the parent, about behavioral problems that children are having in school and kind of saying like, can you pick them up? But they're not documenting that as a suspension. And it should be, right? Like, are you saying I have to pick up my child? Or are you saying you can't serve my child right now? Rights kick in if they're treating it as a suspension. If it's off the books and kind of hush hush, we can't handle them, right? You're losing your rights as parent. And the school's getting off easy instead of figuring out how to better serve your child. So keep logs. Even if you don't end up picking up the child that day, the fact they called, right? That's evidence that they didn't know how to deal with the conflict. Put all the requests you make of a school in writing and ask a written response, right? Confirmation that they received it. And, I think that so much, a colleague of mine calls it like the bureaucratic violence of like ignoring you, right? So many things like just get ignored, or somebody says they'll do something and don't follow through with it. But if you have it in writing that you are going to get sent home, your own assistive technology device to work with your child over the summer, get that in writing. Come prepared, right? I'm sure y'all will because you're at this presentation, but whether it's the discipline hearing or that CSU intake thing talking about, or just an IEP meeting, right? Read ahead of time, make your own personal agenda. This is what I want to make sure I communicate at this meeting. This is what I want them to know about my child. And be the expert on your child. This is a big one, right? Nobody knows their child better than you do. And people may have preconceived notions, especially in these systems, about your child and what they need, or what you as a parent have or haven't done, or things like that. You know best whether a certain discipline consequence will help or exacerbate the situation with your child. So name it. And don't be afraid to hit the pause button. This is what I always tell parents going into IEP meetings, but it's equally true in these disciplinary proceedings or going through the court process. If you don't understand something, ask for a pause so that it can be clarified to you. Or if you feel like you're getting into some territory, like they just want you to sign off on something and it doesn't feel right to you, like hit the pause button, don't sign it, consult an attorney, right? You can call our office. If it's a court proceeding, talk to folks there. You may get some eye rolls and some frustrated sighs and things like that, but really it's the parents that can like push back on that and like, advocate for their child to end up getting the results that they really want, despite whatever pushback from the school.